on the record on cause number DC 23-15266, Romero versus Lopez and DISD. Counsel, make your appearances.
Marissa Maggio on behalf of plaintiff.
Daniel Black on behalf of defendant Dallas ISD.
Diego Esparza on behalf of Mr. Omar Lopez.
All right, go ahead and proceed.
Your Honor, defendant Dallas ISD filed this motion for summary judgment. It's our position today that there is no genuine issue of material fact in this case, given that the plaintiff has failed to present any evidence that creates more than a mere suspicion that a school bus owned and operated by Dallas ISD was involved in this incident. The plaintiff has only brought Dallas ISD into this case based on the testimony of defendant Omar Lopez. The plaintiff has no actual knowledge of whether the claimed school bus collided with Mr. Lopez's vehicle on October 22nd, 2021. She has no actual knowledge that the claimed school bus was owned and operated by Dallas ISD. Again, the plaintiff is relying solely on the deposition testimony of Mr. Lopez. And the other evidence in this case actually fails to corroborate and even contradicts his description of the events that took place. For example, Mr. Lopez testified that on the date of the incident, the weather conditions were sunny, there was no rain and any inclement weather. However, the plaintiff testified that it had been raining that morning, and that Omar Lopez even admitted to her after the accident that his vehicle had slid and he couldn't brake in time to avoid the accident due to the rain and wet road conditions. As for how the incident occurred, Mr. Lopez claimed that a Dallas ISD school bus collided with the hitch of his SUV and then sideswiped his driver's side rear bumper while switching lanes. The pictures produced by the plaintiff show no evidence of paint damage or scraping on the rear bumper, and there's extremely minor displacement of the rear bumper panels. It was also the opinion of the investigating police officer on the scene that it was highly unlikely that a school bus could have struck Mr. Lopez's vehicle with enough force to actually push it forward into the plaintiff's vehicle without leaving any sort of visible damage. Further, Mr. Lopez stated that the vehicles were in heavy traffic and only moving roughly 10 to 15 miles per hour. The plaintiff testified she was actually boxed in at the time of the incident. And if that was the case, it's hard to believe that a school bus would be able to collide with Mr. Lopez's vehicle, switch lanes, collide with his vehicle a second time, as he claims, and then drive away out of the immediate vicinity through heavy traffic without being identified, as there was an officer who was already on the scene at the time of the incident who walked over and took the statements of both parties. And so today, Your Honor, Dallas ISD's position is that the testimony from Mr. Lopez is inconsistent with the other evidence and is so weak that it creates no more than a mere suspicion that a school bus, let alone a Dallas ISD school bus, was involved in this incident. And therefore, Dallas ISD is respectfully requesting that his motion for summary judgment be granted. Thank you.
Response?
We have a difference in testimony and enough here for the jury to have to sort through this. Mr. Lopez did say that he saw DISD on the back of the bus, that the bus hit him. Plaintiff does testify that she did see a yellow bus at the scene. Obviously, she wasn't looking behind her, so she couldn't see, how the collision exactly occurred. And his testimony, Lopez's testimony, and plaintiff's testimony that she saw a bus there at the scene has to be given weight pursuant to the case law for no evidence MSJ. If you look at also the repair to Mr. Lopez's vehicle, it shows that he had rear bumper damage from this incident besides front bumper from colliding with plaintiff. And as well, the photos do show that his bumper on the left and right side, is tilted down. It shows, the photos show what the repair that was done. So we believe that there is more than just a mere scintilla, but adequate evidence for there to be a fact dispute to go before the jury.
Mr. Esparza?
Mr. Lopez has no position on this, Judge. We defer to the court.
Yeah, I think this is kind of classic summary judgment. I think there's a fact issue about what happened, especially since there's proof that there was a rear collision. It may the jury may come in and say 10% or 0 or whatever on DISD. I don't know. But I do think there's a fact issue, summary judgment's denied. All right, guys, anything else we need to chat about? Do you have a trial setting coming out?
Yes,
Yes.
it's in November.
Let me see. I will tell you, we're trying cases here. It's 11/19. Let me just mention something to you guys about that trial setting. I have about 70 cases, I think, or 60. How many do we have now then, Rhonda? It's about 60 or 70. I'm kind of treating that, since we don't have non-jury weeks anymore, or very few of them, I'm treating that kind of a non-jury week. So y'all might want to talk about moving the trial setting a week up, or maybe the week after, sometime in December. I don't mind keeping you then, but that week I'm gonna try the non-juries first, because we have so many of them. We're just kind of piling them all into that one week. So do y'all want to look at a different date, or what do y'all think? Or do you just want to kind of ride the docket and see what happens?
I think we can do that, because I do know that Mr. Black's firm had mentioned to me that they had another trial, I think maybe that week. So I'm get the feeling that we'll be moving up the week before or the week after, so that they're not double booked.
You want
Yes.
to go ahead and move it now, or what do you want to do?
Oh, yeah, I mean, we could do that now. So Mr. Black, what do you want to do, the week before or week after?
Probably preferably the week after, or even further than that. I think that we've talked about wanting to do a bit more discovery and take a few other depositions. So I'm not sure how much time we'll need based on everyone's schedule to get those set up. But we were thinking about filing a continuance. So I'm not sure if pushing it a week past would give us enough time for that. I don't know if that would be something you'd be willing to grant, Judge, if we filed a continuance on that.
Possibly. Your chances are better to move it right now if you can. I would suggest maybe, have a very busy rest of the year. You said, Rhonda, on December 3rd, it's mostly DCADs. Is that what you said?
Yes.
So December 3rd might be a good one, because most of our other trials are what I call DCAD cases, and those really go to trial. We do have a couple pretty big cases ahead of you, potentially ahead of you, but I would suggest maybe December 3rd, if that works for y'all.
That works for me.
I think we can be agreeable to that as well.
And if it simplifies things for the court, Judge, I know that Marissa and I have come to a resolution, at least on our portion of the case, involving Mr. Omar Lopez.
Oh, is that right?
Yes.
So are you still in the case, or has Mr. Black sued you, or?
I don't think you guys crossed us in, did you, Daniel?
We have not crossed, no.
Okay. All right. Rhonda, go ahead and move this case and send him a new trial setting. Have you already been to mediation on this?
Yes.
Yes.
Okay. All right. Go ahead and send him a new trial notice for December 3rd. And you guys have a great rest of your day. Okay.
All right.
right.
Thank you, everyone.
Thank you.
Take care.
Yeah.
Bye.
Just I just sent you an email.